Case 1, Michelle Martins. August 23, 2016. 2nd Judicial District Court, Bernalillo County, New Mexico. There are names that a city never forgets. Names that become permanently woven into the fabric of a community's conscience. Not because the community chose to hold on to them, but because what happened was simply too significant, too heartbreaking, too preventable to allow the silence to settle. In Albuquerque, New Mexico, Victoria Martins is one of those names. She was 10 years old, and on the very morning that should have been filled with birthday candles and laughter, and the kind of joy that belongs only to childhood, the city of Albuquerque was instead forced to confront one of the most devastating failures of parental responsibility in its recorded history. What investigators found inside that Northwest Albuquerque apartment on August 23, 2016 did not arrive without warning signs. That is the part of this story that demands examination. That is the part that this documentary exists to shine a light on. Not to sensationalize tragedy, but to ask the honest and necessary question. What combination of choices, conditions, and individual failures allowed a 10-year-old child to be placed in harm's way by the one person who was supposed to protect her above all others? Michelle Martins was Victoria's mother. She had been raising Victoria and her younger brother in the apartment complex on the northwest side of Albuquerque. On the surface, the household functioned as any struggling single-parent home might, navigating finances, relationships, and the daily pressures of raising children in a major American city. But beneath that surface, a series of decisions had been made that were creating a deeply dangerous environment for the children living there. Michelle had entered into a relationship with a man named Fabian Gonzalez. Gonzalez moved into the apartment approximately 1 month before the events of August 23. He brought with him a connection to his cousin, Jessica Kelly, who had recently been released from prison. Kelly was also permitted to reside in the apartment. The household now contained individuals with significant criminal histories, and at least one of them, investigators would later confirm, was actively using methamphetamine during the period leading up to what occurred. The investigation that followed Victoria's death would ultimately involve multiple agencies, a DNA-based search for an unidentified fourth suspect, and years of court proceedings. The Albuquerque Police Department's initial response to the scene on the night of August 23 prompted an immediate and sweeping investigation. 3 adults, Michelle Martins, Fabian Gonzalez, and Jessica Kelly, were taken into custody within 24 hours. All 3 were initially charged with serious crimes, including child abuse resulting in death. As the investigation deepened, the picture became more complex. Forensic analysis and subsequent court testimony revealed that Martins and Gonzalez were not physically present in the apartment at the precise moment that Victoria lost her life. Prosecutors determined that Jessica Kelly was in the apartment at the time, and that she had been in an erratic and highly altered state. Evidence pointed toward a fourth individual, an unidentified male whose partial DNA profile was recovered from the scene, and a grand jury later returned an indictment against this individual, referred to in court documents as John Doe, whose identity has not been publicly confirmed as of this writing. The legal theory applied to Fabian Gonzalez was that, while he may not have directly caused Victoria's death, he had set in motion the series of events and conditions that created the environment in which that death became possible. He had introduced dangerous individuals into the home. He had participated in the concealment of what occurred. A jury convicted him at trial in August of 2022 on charges of reckless child abuse resulting in death, along with tampering with evidence and conspiracy to tamper with evidence. He was sentenced to 37.5 years in prison by 2nd Judicial District Judge Cindy Leos in October of 2022. Jessica Kelly, who had been present in the apartment when Victoria lost her life, entered a plea agreement in which she pleaded no contest to child abuse recklessly caused resulting in death, along with tampering with evidence and aggravated assault. Because she had 2 prior felony convictions, she was sentenced as a habitual offender. Judge Charles Brown sentenced Kelly to 44 years in prison in April of 2022. And then there was Michelle Martins. On June 29, 2018, almost 2 years after Victoria's birthday became the last day of her life, Michelle Martins entered a guilty plea to 1 count of intentional child abuse resulting in death. The court accepted that plea. Martins acknowledged in the terms of that agreement that she had failed to protect her daughter. She acknowledged that her negligence and her choices had directly contributed to the circumstances that led to Victoria's death. Prosecutors had argued from the beginning that the environment Martins created and maintained, the people she allowed access to her home and to her children, represented a catastrophic abdication of parental responsibility. The sentencing hearing for Michelle Martins was held on November 10, 2022, delayed until after the conclusion of the Gonzalez trial. Judge Cindy Leos sentenced Martins to 12 years in the New Mexico Department of Corrections. It was the minimum end of the sentencing range contained within her plea agreement. Victoria's grandparents were present in the courtroom throughout much of the proceedings. They had sought answers and accountability from the very beginning. The case generated widespread public outcry in Albuquerque and across New Mexico, prompting renewed conversations about child welfare systems, the responsibilities of parents who introduce high-risk individuals into households with children, and the adequacy of the protections available to children who cannot speak for themselves. Victoria Martins was born on August 23, 2006. She did not live to see her 11th birthday. She did not have the chance to choose the people in her life, to determine the environment she occupied, or to remove herself from danger. Those choices belonged to her mother. And those choices, the ones made and the ones not made, are precisely what the court of Bernalillo County was called upon to examine, to judge, and to hold accountable. The justice system in this case moved slowly and unevenly, as justice systems often do. But by the close of 2022, all three of the individuals initially charged had been sentenced. The fourth suspect, the unidentified man whose DNA evidence was recovered from the scene, remained unidentified as of the most recent public reporting. The investigation into his identity remains open. What this case leaves behind, beyond the legal record, is a reminder that children depend entirely on the decisions of adults. They cannot audit the people moving through their homes. They cannot evaluate risk or remove themselves from danger. A 10-year-old girl in northwest Albuquerque trusted that the adult responsible for her was making choices that protected her. That trust was not honored, and the consequences of that failure were permanent and irreversible. Victoria Martins deserved better. The courts of Bernalillo County said so. The community said so. And this documentary says so. If you or someone you know has concerns about the safety of a child, please contact the Child Help National Child Abuse Hotline at 1-800-4-A-CHILD. That is 1-800-422-4453. Trained counselors are available 24 hours a day, 7 days a week. If this case moved you, if it reminded you why accountability matters and why children's voices deserve to be heard, please take a moment right now to like this video and subscribe to Cold Case Hour. Every subscription helps this channel continue bringing these important stories to light. We have 9 more cases to cover tonight, and every single one of them demands your attention. Case 2, Gloria Tosillo. July 16, 2023. 2nd Judicial District Court, Bernalillo County, New Mexico. There is a particular kind of grief that settles over a community when the victim is an infant. When the person who lost their life had not yet learned to walk, had not yet spoken their first word, had not yet been given a single fair chance at the world, the weight of that loss lands differently. It does not simply generate sadness. It generates a demand for answers. It generates the kind of question that communities cannot and should not stop asking. How does a child this young, this vulnerable, this entirely dependent on the adults around her, end up in the circumstances that claimed her life? On July 16, 2023, Albuquerque Police Department officers were dispatched to a Days Inn motel located near the intersection of Interstate 40 and Coors Boulevard, NW, in northwest Albuquerque. The call that sent them there was about an unresponsive infant. What they found when they arrived, both the condition of the child and the condition of the room, would form the basis of a criminal case that a Bernalillo County jury would ultimately take less than 30 minutes to decide. Keely Gabaldon was 6 months old. She was one of twin daughters born to Gloria Tosillo and Lawrence Johnny Gabaldon. The family had been living and working at the Days Inn. Tosillo was employed there, and the motel room served simultaneously as workplace and home for the family, including the 2 infant girls. What should have been a temporary and difficult but manageable living arrangement had instead become something far more dangerous for those babies. Prosecutors described the motel room in unambiguous terms during trial. They characterized it as a location where narcotics were being regularly consumed, where drug paraphernalia was scattered throughout the space, including within reach of the infants, and where the air itself carried the chemical residue of substances being used regularly and without restraint. Officers who responded to the scene reported a strong chemical odor consistent with narcotics upon entering the room. What they observed scattered throughout the space included foil used for smoking substances, straws, a scale, prescription pills, a powdery residue coating portions of the floor, and an open container of baby formula positioned in the same proximity as a container of bleach. Surveillance footage from the motel's security system showed Lawrence Gabaldon running frantically into the lobby on the morning of July 16th. A security guard identified him. He was calling for Tasillo. The words he used, captured in the investigative record, reflected the desperation of someone who had just found an infant in a condition he could not explain. Officers were flagged down nearby and directed to the room. When they arrived, Keely was lying on a bed in the room. She was unresponsive and not breathing. Both responding officers and Albuquerque Fire Rescue attempted emergency, life-saving measures. Those efforts failed. Keely Gabaldon was pronounced dead. The investigation that followed was thorough and meticulous. The Office of the Medical Investigator conducted an autopsy that established the cause of Keely's death with clarity: the toxic effects of methamphetamine. There were no signs of physical injury of any other kind. The pathway by which a 6-month-old infant came to have a lethal concentration of methamphetamine in her system was through the environment in which she was being kept, the same air that the adults in that room were breathing, the same surfaces those infants were lying on, the same space saturated with the residue of the substances being used around them. To further underscore the degree to which the surviving twin had been exposed, investigators arranged for a hair follicle test to be conducted on Keely's sister. The results were staggering. That test came back positive for cocaine, fentanyl, methamphetamine, benzodiazepines, and cannabis. A 6-month-old infant. Both of them had been living in a room where those substances were present in concentrations sufficient to register on a toxicology screen conducted on a child too young to have any possible voluntary exposure to such substances. The only source was the environment. The environment was the responsibility of her parents. During the subsequent criminal proceedings, the question of individual responsibility was contested. Tasillo's attorney pointed to the father, Lawrence Gabaldon, noting that the evidence established he had been the adult physically present in the room with the infants when the emergency occurred. Gabaldon had admitted to law enforcement that he was supposed to have been watching the children, that he had used fentanyl, and that he had lost consciousness, and that when he regained awareness, Keely was already gone. But the prosecution's theory was not limited to who was physically in the room at the moment of crisis. The theory was broader and more fundamental. Gloria Tasillo, as the mother of these infants, had participated in creating and maintaining the environment that made Keely's death not just possible but predictable. She had been living in that room. She had been working in and around that room. She knew what was in it. She knew what was happening in it. And she had continued to keep her 6-month-old twins in it. The jury in the 2nd Judicial District Court of Bernalillo County deliberated for approximately 30 minutes before returning their verdict on May 22, 2024. Gloria Tasillo was found guilty of first-degree child abuse resulting in the death of Keely Gabaldon. She was also convicted of a separate count of third-degree child abuse in connection with the surviving twin. At sentencing, 2nd Judicial District Judge Cindy Leos imposed the mandatory minimum term for the first-degree conviction, 18 years in the New Mexico Department of Corrections. Tasillo was 31 years old at the time of sentencing. The surviving twin, who had tested positive for multiple controlled substances before her first birthday, was placed into the custody of the New Mexico Children, Youth, and Families Department. Lawrence Gabaldon was separately charged with 6 felony counts, including first-degree child abuse resulting in Keely's death, third-degree child abuse in connection with the surviving twin, and 4 felony drug charges. He was ordered held without bond pending trial as of the most recent reporting available. A family that should have been building a life together, finding housing, establishing stability, providing the kind of safe and nurturing environment that 2 infant girls deserved from their very first days, had instead created conditions that no child should have been anywhere near. Keely Gabaldon never got to see her first birthday. She never got to take her first steps, or speak her first word. She lost her life not through any act of her own, not through any failure of her own, but through the choices made by the adults who were supposed to be her protection. The Second Judicial District Court of Bernalillo County delivered a verdict that reflected the gravity of those choices. 18 years. Mandatory. No discretion to reduce it. The jury and the court said clearly and on the record, what happened to Keely Gabaldon was not an accident in the way that word is commonly understood. It was the foreseeable consequence of a foreseeable environment. And someone had to be held responsible. Keely deserved a different beginning. What the justice system could do, it did. What it cannot do is give that child her life back. That is why stories like hers must be told, why they must be examined, and why the people who allow these environments to exist around their children must understand that the courts of this country will hold them to account. If this case affected you, please do not scroll past without taking a moment to like this video and subscribe to Cold Case Hour. These children deserve to be remembered, and your support helps us continue this work. Stay with us. We have 8 more cases ahead. Case 3, Amelia Garcia. April 6, 2025. Second Judicial District Court, Bernalillo County, New Mexico. There is a conversation that child safety advocates have been having in courtrooms, in classrooms, in legislative chambers, and in the homes of parents across this country for years. It is a conversation about firearms and children, specifically about the lethal intersection of an unsecured weapon and the natural, uncontainable curiosity of a very young child. That conversation is not abstract. It has real faces attached to it. On April 6, 2025, in a southeast Albuquerque apartment, one of those faces belonged to a 2-year-old boy named Leon Garcia. Leon was Amelia Garcia's son. He was 2 years old, at the stage of childhood where the world is one enormous object of fascination, where every item within reach becomes something to examine, to pick up, to turn over in small hands. A 2-year-old does not understand what a firearm is. A 2-year-old does not understand consequences. A 2-year-old does not understand the difference between a toy and a loaded weapon. The adults in that child's life bore the complete and undivided responsibility for making that distinction for him, for ensuring that the most dangerous object in that apartment was nowhere within his reach. That responsibility was not met. According to the criminal complaint and subsequent court proceedings, Amelia Garcia, who was 20 years old at the time, had acquired a handgun fitted with an extended magazine. She later told investigators she had purchased the firearm for protection, citing a prior domestic dispute with a family member. The existence of a personal safety concern does not in itself constitute wrongdoing. What happened next, however, is what the courts of Bernalillo County were called upon to examine. On the morning of April 6, 2025, Amelia Garcia left the loaded handgun unattended in the living area of the apartment, in the same space where her 2-year-old son was present without direct supervision. Garcia told investigators she was in another part of the apartment when she heard a loud sound. She went into the living room. What she found there was her son, Leon, with a gunshot wound. The weapon was near his body. Leon Garcia sustained a gunshot wound to the chest. He did not survive. What happened in the immediate aftermath of Leon's injury compounded an already devastating situation in a way that would become central to the prosecution's case. According to investigators, 3 other adults who were present in the apartment at the time, later identified as Angel Cordova, Angelica Lucero, and Angel Morales, took the firearm from the scene and left the apartment before emergency services arrived. They did not stay to assist. They did not remain to speak with first responders. They removed the weapon and departed, which investigators characterized as an active and deliberate effort to interfere with the investigation that would follow. All 4 individuals, Amelia Garcia along with the 3 adults who fled, were arrested and charged. The 3 others faced charges of tampering with evidence. In April of 2026, a jury convicted Angel Morales on 2 counts of tampering with evidence and conspiracy to commit tampering with evidence following a full trial. As for Amelia Garcia, on March 24, 2026, nearly a year after Leon's death, Garcia appeared before Second Judicial District Judge David Murphy and entered guilty pleas to child abandonment resulting in death from a firearm and tampering with evidence. The judge accepted the plea. Garcia's sentencing was scheduled for a later date, with her attorney noting that the range she faced ran from 0 to 10 years, meaning the court retained the discretion to impose any sentence within that range, including the possibility of a probated outcome contingent on treatment. A prosecutor had noted during an earlier phase of the proceedings that the evidence established clearly what had happened. The boy had found the weapon and it had discharged. The tragedy was not one of malicious intent, but the law in New Mexico, and the principles of child welfare that underpin it, does not require malicious intent to establish criminal responsibility for the death of a child. It requires a finding that the adult responsible for that child failed in their duty of care. And that duty, the court determined, was violated when a loaded firearm was left within the reach of a 2-year-old. New Mexico has in recent years passed legislation specifically addressing secure firearm storage in households with children. The case of Leon Garcia is precisely the kind of case that legislators point to when making the argument for such laws. A 2-year-old cannot be expected to understand what a firearm is. A 2-year-old cannot be told to leave something alone and be relied upon to honor that instruction when curiosity overtakes instruction. The only way to protect a child that young from a loaded weapon is to make the weapon physically inaccessible to them. Full stop. No exceptions. Leon Garcia did not have that protection on April 6, 2025. He was 2 years old, and the choice that placed him in danger was not his. The guilty plea entered by Emilia Garcia in March of 2026 represented a formal acknowledgement in the record of Bernalillo County's 2nd Judicial District Court that the choices made that morning led directly to Leon's death. The sentencing that follows will determine what the court believes justice requires in this specific case. But the legal record, the plea, the verdict against Morales, the acknowledgement of what occurred, stands as the judicial community's response to the loss of a child who deserved to be protected. There are resources available to parents who need support in navigating the complexities of raising young children in environments where firearms are present. Safe storage options, trigger locks, secure vaults. These are not difficult solutions. They are inexpensive, widely available, and they work. The difference between a secured firearm and an unsecured one can be the difference between a child who grows up and a child who does not. Leon Garcia deserved to grow up. The system did what it could to ensure accountability for what happened. The community of Albuquerque, and every community where young children are present, owes it to children like Leon to take the message of this case seriously. If this case moved you, if it reminded you of something important, please like this video right now and subscribe to Cold Case Hour. Your engagement keeps this channel going and helps these stories reach the people who need to hear them. We have 7 more cases tonight. Case 4, Edith Estrada Sigala. March 3, 2025. 2nd Judicial District Court, Bernalillo County, New Mexico. There are moments in a child welfare investigation where investigators arrive at a scene and are confronted not with complexity, but with clarity. The evidence is not ambiguous. The sequence of events, once reconstructed, does not leave meaningful room for alternative interpretations. What happened is plain, and the only question that remains is, how did it get this far? March 3, 2025, was a Monday. Albuquerque Fire Rescue was dispatched to a home on San Pablo Street SE in southeast Albuquerque in response to a call about a baby who was barely breathing. The address was the residence of Edith Estrada Sigala, 28 years old. The baby was her 7-month-old son, identified in court documents by his initials, AD. When first responders arrived at the San Pablo Street address, they found the infant unresponsive. They initiated emergency life-saving measures immediately. Those efforts continued until it became clear they could not be sustained. AD was pronounced dead. Albuquerque Police Department officers arrived on the scene as fire rescue continued their work and began conducting interviews. The story that Estrada Sigala initially offered to investigators did not hold. She told first responders that her son had been dealing with pneumonia for approximately 3 weeks and that she had put him down for a nap, later finding him unresponsive. That account, of a sick infant placed down for a rest, is the kind of explanation that sounds plausible in isolation. Sick infants do sometimes lose their lives. Tragically, and without warning, infant deaths do occur. But the physical evidence surrounding this case told a different story, and as the interview continued, that different story began to emerge from Estrada Sigala's own account. The bathroom where AD was found contained running water. Officers searching the apartment located evidence of significant alcohol consumption throughout the residence, including in the bathroom itself and in the mother's bedroom. When investigators counted the empty alcohol containers found throughout the apartment, the total came to 18 empty bottles of alcohol. In the course of their interview, Estrada Sigala broke down and disclosed a significantly different account of what had occurred. She told investigators that on the morning of March 3, 2025, she had consumed vodka. She acknowledged she had been drinking. She described taking her older son to school and then returning home with AD. She described deciding to give the 7-month-old a bath sometime after 2 in the afternoon, placing him in a half-filled tub with a bath seat and some toys. Then she described walking away from the bathroom, initially to attend to laundry, and then she described lying down. She told investigators she had no intention of falling asleep. But she did fall asleep. Hours passed. Estrada Sigala's mother, the baby's maternal grandmother, had been attempting to reach her daughter throughout the afternoon with no success. Growing concerned, she went to the apartment herself and knocked. She eventually made her way inside and woke Estrada Sigala. When she asked about the baby, Estrada Sigala reportedly told her she thought he was in his bassinet. They went to check. He was not in the bassinet. He was in the bathtub. He had been there for hours. He was found unresponsive in the water by the grandmother, who immediately began CPR alongside Estrada Sigala while emergency services were called. But by the time Albuquerque Fire Rescue arrived, it was too late. Edith Estrada Sigala was arrested and charged with child abuse resulting in death. She was booked into the Bernalillo County Metropolitan Detention Center. In subsequent proceedings, a grand jury returned a formal indictment on the same charge, child abuse resulting in death, after examining the evidence compiled by investigators. Her case was pending trial as of the most recent available reporting. The details of this case are not complicated. A 7-month-old infant cannot remove himself from a bathtub. He cannot call for help. He cannot recognize that the water around him represents a threat to his life. He cannot do anything except exist in the environment that the adult responsible for him has placed him in. When that adult is impaired, when that adult falls asleep, when that adult is no longer present to provide the supervision that a 7-month-old in a tub of water requires continuously and without interruption, the result can be exactly what happened on San Pablo Street on March 3, 2025. Courts across the country have grappled with cases of this kind. The legal standards differ by jurisdiction, but the underlying principle is consistent. Placing an infant in a situation of known danger and then removing the supervision that stands between the infant and that danger is an act that carries legal consequences. In Bernalillo County, the grand jury that reviewed this case determined that the facts as established warranted a formal charge of child abuse resulting in death. The official toxicology reports, the detailed crime scene documentation compiled by APD investigators, and the statements Estrada Sigala made during interviews with law enforcement all contribute to a record that the courts of the 2nd Judicial District will ultimately be called upon to evaluate. As of this writing, that evaluation is pending. What is not pending is the loss. AD, 7 months old on March 3, 2025, did not survive. He had barely been alive long enough to discover the world, to begin recognizing faces, to start forming the first tentative connections that infants form with the people around them. He had not yet had a chance. And the adult responsible for ensuring he got that chance made choices on that Monday afternoon that took it from him. The courts of Bernalillo County will have the final word on what accountability looks like in this case. But accountability begins before the courtroom. It begins with the choices made in a bathroom, in a living room, in the daily decisions of the adults charged with keeping the most vulnerable people in our society safe from harm. AD deserved that safety. He did not receive it. And the record of the 2nd Judicial District Court of Bernalillo County reflects that fact. If this case made you stop and think, if it reminded you of something important about the responsibility we carry toward the youngest and most vulnerable among us, please take a moment to like this video and subscribe to Cold Case Hour. What we do here matters only if people are watching. Stay with us. 6 more cases remain. Case 5, Tabitha Molina. Late May, 2026. 2nd Judicial District Court, Bernalillo County, New Mexico. Some of the cases that come before the courts of Albuquerque carry with them a particular dimension of urgency that sets them apart. not simply because of the gravity of what occurred, but because of what was known before it occurred, because of the history that existed, because of the trail of documented concern that preceded the tragedy, and the question that hangs in the air afterward. What more could have been done to prevent this? The case of Tabitha Molina is one of those cases. It is recent, it is raw, and it demands the kind of careful, thorough examination that only a full accounting of the known facts can provide. The events that led to criminal charges against Tabitha Molina, 32 years old, began in late May of 2026. On the evening of May 22nd, officers were dispatched to the University of New Mexico Hospital following a report from the New Mexico Children, Youth, and Families Department, commonly referred to as CYFD. A 1-year-old child had been brought to Presbyterian Hospital, then transferred to UNM Hospital, in critical condition. That child was Anastasia Molina, the daughter of Tabitha Molina. When medical personnel examined Anastasia at the hospital, they found injuries that were inconsistent with the explanation her mother had provided. Tabitha Molina had told staff that Anastasia had fallen face-first from a couch and lost consciousness. Medical professionals who reviewed the child's condition documented what they observed clearly and without ambiguity: bruising across the child's body, injuries to her head, and ultimately a diagnosis that investigators described as a skull fracture. The injuries were not consistent with a fall from a couch. They were not consistent with the kind of accidental domestic mishap that a parent might attribute to a toddler's natural clumsiness. What they were consistent with, according to the criminal complaint filed by the Albuquerque Police Department, was a pattern. Investigators concluded, based on the medical evidence and their investigative work, that the injuries documented at the hospital had not all occurred in a single incident. The abuse, in their assessment, had taken place on multiple occasions over a period of time preceding the hospitalization. Anastasia had been living with these injuries. She had been carrying them without any adult intervention on her behalf. Anastasia was placed on life support at UNM Hospital following her admission. She remained there for approximately 1 week. On May 29, 2026, she was removed from life support. She passed away. She was just 2 months short of her second birthday. What made this case particularly painful for those who followed, it was the information that emerged about CYFD's prior involvement with Tabitha Molina. The department publicly confirmed in the days following Anastasia's death that Molina had a documented history with the agency stretching back to at least 2019, more than 6 years before Anastasia died. That history involved her 3 older sons, who were no longer in her custody. The record included a substantiated allegation of neglect due to inadequate shelter in February of 2020. Additional reports in late 2021 were investigated, but not substantiated. Services had been provided. Counseling had been ordered and apparently attended. And yet Anastasia was in her care. And Anastasia did not survive. Anastasia's maternal grandmother, who stated that she had only learned of her granddaughter's existence approximately 2 weeks before the child's death, spoke publicly after the arrest. Her words were simple and devastating. She described what she had told Anastasia during the brief time she knew her: that she was loved, that she was wanted, that she was safe. And she's safe again, the grandmother said. Tabitha Molina was arrested on June 4, 2026, 6 days after Anastasia's death. She was booked into the Bernalillo County Metropolitan Detention Center and charged with 2 counts: intentional child abuse resulting in the death of a child under 12, and child abuse. A pretrial detention motion filed by prosecutors described the offense in stark terms, characterizing the conduct as the deliberate neglect and abuse of a child to the point of catastrophic injury. A judge ordered Molina held pending the resolution of the case. The Office of the Medical Investigator was in the process of conducting an official autopsy to establish the formal cause of death, as of the most recent reporting available. The criminal case against Molina was at its early stages as of June of 2026. What this case places into sharp focus is a question that Albuquerque and the entire state of New Mexico have been grappling with across multiple tragic cases in recent years. What is the appropriate threshold for intervention when a documented pattern of concern exists, and a child's continued placement with a parent represents a known variable in that child's safety equation? The CYFD system, underfunded, understaffed, operating under enormous case loads, does not make these decisions lightly. But the outcome in Anastasia's case has added her name to a list that the advocates, the legislators, the social workers, and the community at large have been unable to stop growing. Anastasia Molina was 1 year old. She was almost 2. She had a grandmother who loved her from the moment she knew she existed. She had a life ahead of her that the court records of the 2nd Judicial District of Bernalillo County will now be asked to account for. That accounting has begun. Where it leads will be the subject of future proceedings. What this documentary can say with certainty is this: a child was in danger. The signals were present. The history existed. And a 1-year-old girl paid the price for a series of adult failures that no child should ever have to pay. The justice system is now in motion. The community of Albuquerque is watching. And Anastasia Molina will not be forgotten. If you are watching this and you feel compelled to act, if this case has reminded you that every child deserves to be safe, please like this video and subscribe to Cold Case Hour. Share this content with someone who needs to hear these stories. Your support is how these children's stories continue to be told. 5 more cases remain tonight. Case 6, Alexis Bernal. Mid-2024. Bernalillo County Sheriff's Office Jurisdiction, 2nd Judicial District Court, Bernalillo County, New Mexico. In the landscape of child welfare cases, there exists a category of circumstance that is perhaps the most difficult to fully comprehend from the outside. The case in which the person responsible for a child's well-being was aware of the harm being done to that child, did not cause it directly, but also did not stop it, did not report it, did not leave, did not intervene. Instead, continued to remain in the household, continued to present a false account to the outside world, and allowed the harm to continue. This is the category into which the case of Alexis Bernal falls. And it is a category that the courts of Bernalillo County have been required to address with particular care. In mid-2024, Alexis Bernal brought her 1-year-old daughter to a hospital in Albuquerque. The explanation she offered to medical staff was simple and unremarkable. Her daughter had gotten her legs stuck in a baby carrier. It is the kind of thing that sounds like it could happen. Baby carriers are worn. Children squirm. Legs get into awkward positions. A concerned parent taking a child to be checked out. That is not unusual. That is responsible parenting. But when the medical staff began their examination of Bernal's daughter, what they found bore no relationship to the explanation that had been offered. The child had 8 broken ribs. She had fractures to both arms and both legs. She had a fractured foot. She had torn neck muscles. She had bruising and scratches across her body. She had bleeding gums. And critically, as the medical professionals reviewing her case noted, these injuries were not all the result of a single event. They were in different stages of healing. Some were recent. Some were not. The pattern of injuries told the story of a child who had been subjected to repeated harm over an extended period of time. Harm that had been occurring, according to the evidence, since at least January of 2024, when daycare staff had begun noting changes in the child's behavior and documenting physical signs that concerned them. Investigators with the Bernalillo County Sheriff's Office built their case carefully. They interviewed people who knew the family, people who interacted with the child regularly, and they assembled a picture of what had been happening inside that household. A daycare teacher described the child during the period when Bernal's fiancée, Augustine Solis-Baca, had become a regular presence in the family, sitting motionless while all the other children crawled and climbed and babbled. Not moving, not engaging, just watching. The behavioral change was stark and documentable, and it coincided precisely with Solis-Baca's introduction into the child's environment. Both Alexis Bernal and Augustine Solis-Baca were arrested on charges of child abuse resulting in great bodily harm. The paths their cases took through the court system diverged significantly. Solis-Baca's case proceeded toward trial and ultimately to a plea. In March of 2026, Solis-Baca entered pleas of no contest to 6 counts of child abuse, including 3 counts of child abuse resulting in great bodily harm. As of the most recent available reporting, his sentencing was pending, with the possibility of up to 6 years in prison. Alexis Bernal's resolution came in a manner that generated significant public discussion. In April of 2025, she pleaded guilty to 2 counts of child abuse. Her role, as established in the court proceedings, was not that of the person who directly inflicted the injuries. The prosecution's evidence pointed to Solis-Baca as the person who physically harmed the child. Bernal's culpability, as acknowledged in her plea, was that she had known what was being done to her daughter and had concealed it. She had agreed to testify against Solis Baca. She had admitted, in the words of her own statement to the court, that she had placed her child in a situation she would regret for the rest of her life. In May of 2026, Judge Britt Baca of the 2nd Judicial District Court sentenced Alexis Bernal under a conditional discharge. Under that arrangement, if Bernal completes 5 years of supervised probation and attends parenting classes as ordered, she will not serve prison time. If she violates the conditions, the matter returns to court for further proceedings. The reaction to that sentence was mixed. Victim advocates pointed out that Bernal's daughter, who was healing, according to her father, but showing signs of significant psychological distress, had endured months of harm while in her mother's care. The child's father, who was not Solis Baca, made a statement to the court in which he described his daughter as a soldier, resilient, picking herself up no matter what had been done to her. He said that with visible emotion. The child is healing. The child's father has her. And the record of what was done to her, and the choices made by the adults around her, will remain in the court documents of the 2nd Judicial District of Bernalillo County for as long as those records are kept. There is no comfortable way to sit with this case. There is no easy resolution to the tension between understanding the complexities of how people end up in abusive relationships and the knowledge that a 1-year-old child was left to carry the physical and emotional weight of those complexities on her small body for months before anyone intervened. What can be said is this: the courts acted. The evidence was assembled. The people responsible were charged. And the child, this particular child, survived. That is not always the outcome in cases of this kind. The fact that she is alive, that she is in safe hands, that she is healing, that matters. It matters enormously. And the lesson this case carries for every parent, every guardian, every person who loves a child, is that protection is not passive. It requires action. It requires the willingness to prioritize a child's safety above every other consideration, including the comfort of a relationship, including fear, including the difficulty of what comes next. A child cannot protect herself from the people who have access to her. That responsibility belongs entirely to the adults in her life. This child's father is her protector now, and she is, in his words, a soldier. If this case affected you, if it reminded you of something important about what it means to truly protect a child, please like this video and take a second to subscribe to Cold Case Hour. We have 4 more cases to cover, and every one of them carries a story that needs to be told. Stay with us. Case 7, Vanessa Chavez. August 2nd, 2025. 2nd Judicial District Court, Bernalillo County, New Mexico. There are cases where the most devastating element is not only the tragedy itself, but the context surrounding it. The sequence of decisions made by multiple institutions and individuals. The sequence of events that placed a child in a situation of danger that any number of interventions might have prevented. The case of Vanessa Chavez and her 18-month-old daughter is one of those cases. It is a case that generated not only criminal proceedings, but a public reckoning about the child welfare infrastructure of the entire state of New Mexico. On the morning of August 2nd, 2025, Albuquerque Fire Rescue received an emergency call from a home in the 5600 block of Cleghorn Road NW in northwest Albuquerque. When fire rescue and police personnel arrived, they found the child's father, Gregory Montoya, performing CPR on his 18-month-old daughter in a desperate and ultimately futile attempt to revive her. Emergency personnel took over the CPR effort. They continued for 20 minutes. The child, identified in court documents by the initials EM and identified by her family in public statements as Estria Montoya, could not be revived. She was pronounced dead at the scene. The injuries that investigators documented on Estria's body were significant. There was bruising observable on her head, neck, arms, and legs. An autopsy conducted in the days following her death revealed a large subdural hemorrhage, a serious accumulation of blood between the layers of the brain's covering, consistent with a significant traumatic impact to the head. The manner of death was established as a homicide. What investigators learned next came from the most important witness to what had occurred, Estria's 7-year-old brother. The boy told investigators clearly and without equivocation what he had seen. He told them that his mother, Vanessa Chavez, had been with Estria, and that the baby had been fussing. He told investigators that his mother's feelings had been hurt because the baby wouldn't stop crying. And he told investigators that he had watched his mother slam his baby sister into a wall. The boy had witnessed the death of his 18-month-old sister. He had watched it happen. And afterward, according to the criminal complaint, Chavez had told him that he can't tell what he had seen. He told anyway. And the record of the 2nd Judicial District Court reflects his testimony. Vanessa Chavez was 40 years old when detectives issued a warrant for her arrest on August 6, 2025, 4 days after Estria's death. She was taken into custody and charged with intentional child abuse resulting in death. Prosecutors filed a motion for pretrial detention, characterizing the offense as among the most serious and violent acts a parent can commit. A judge ordered Chavez held without bond pending the resolution of her case. She remains in custody at the Bernalillo County Metropolitan Detention Center as of the most recent available reporting. But the dimension of this case that prompted a statewide conversation goes beyond the crime itself. Estria Montoya had not spent most of her 18 months with Vanessa Chavez. She had been removed from her parents' custody by CYFD shortly after her birth on February 1, 2024. In part because of her parents' failure to bring her to essential follow-up medical appointments related to her premature birth. She had been placed with a family member and had been living there. Both she and her younger sibling had been born with drug exposure in their systems. What changed in the summer of 2025 was the legal status of Estria's custody arrangement. On June 18, 2025, just over 6 weeks before Estria's death, attorneys for Vanessa Chavez and Gregory Montoya appeared at a court hearing and moved to dismiss the ongoing abuse and neglect case. Their argument was that the parents had complied with the requirements of their court-ordered reunification plan. According to a CYFD statement released after Estria's death, all parties at that hearing, including the guardian ad litem, CYFD representatives, the parents' attorneys, social workers from the Office of Family Representation and Advocacy, and the presiding judge, raised no objections to the dismissal motion. The order was signed on July 21, 2025. 12 days later, Estria Montoya was gone. The grief and outrage that followed were immediate and vocal. Child advocacy organizations across New Mexico issued statements calling the death preventable. Marilyn Beck, the founder of the New Mexico Child First Network, stated publicly that every single one of the child deaths connected to CYFD involvement that year had been preventable. Lawmakers called for investigations. CYFD issued a statement expressing condolences and acknowledging the history of their involvement with the family, while stating that the outcome could not have been predicted by any party involved in the case. Whether one accepts that characterization or disputes it, the fact that demands attention is unchanged. An 18-month-old child who had spent most of her short life in protective custody was returned to a household, and 12 days later, her 7-year-old brother was forced to watch her die. The criminal case against Vanessa Chavez is active and ongoing. The charges against her reflect the severity of what the investigation determined occurred in that northwest Albuquerque home. The courts of Bernalillo County will eventually deliver their judgment on the facts as established. What this case asks of every person who hears it is not simply to direct anger at a single individual or a single institution. It asks for a systemic reckoning. It asks for the kind of honest, difficult conversation that results in policy changes, funding increases, better training, and an overall child welfare infrastructure that is capable of doing what it is designed to do. Keep children who are in danger out of situations that will harm them. Estria Montoya was 18 months old. She had a 7-year-old brother who loved her. She had a grandmother somewhere. She had a life, however brief, that deserved to continue. The justice system is pursuing the accountability that the criminal law can deliver. The deeper accountability, the systemic kind, remains the work of the community, the legislature, and every adult in New Mexico who cares about the children in their midst. Estria deserved more. The courts will decide what comes next for Vanessa Chavez. The community of Albuquerque has already decided how it feels. If this case moved you, if it reminded you of why child safety advocacy matters, and why these stories must be told, please like this video and subscribe to Cold Case Hour. 3 more cases remain tonight. Every single one of them is important. Case 8, Carrie Santos. January 12, 2024. 2nd Judicial District Court, Bernalillo County, New Mexico. There are moments in a criminal investigation when the full weight of what has occurred does not reveal itself in a single piece of evidence. It reveals itself gradually, across multiple pieces, multiple statements, multiple examinations, until what began as a confused and incomplete picture crystallizes into something unmistakable. The case that began in the early morning hours of January 12, 2024, at the University of New Mexico Hospital is one of those cases. And the clarity it eventually achieved was both comprehensive and profoundly disturbing. Shortly before 4 in the morning on January 12, Carrie and Santos, 31 years old, with connections to the town of Gardner, Massachusetts, arrived at the University of New Mexico Hospital emergency entrance with 3 young children. One of them, a 3-year-old girl, was wrapped in a blanket. Santos told hospital staff that her daughter had not been feeling well and that they had stopped at a gas station during their travels so the child could use the restroom. She said the girl had fallen from the toilet and hurt herself. Medical staff moved to examine the child. When they attempted to pull back the blanket to assess her condition, Santos reportedly pulled away and asked why they needed to do that. Staff eventually gained access to the child. They brought her into the emergency room, and the information they gathered there made it immediately clear that the child was not merely unwell from a fall. The child was already gone. Law enforcement was called. APD's Crimes Against Children unit was activated. The investigation that followed moved swiftly over the next several hours as detectives built a picture of who was in that hospital waiting room, where they had come from, and what had been happening to those 3 children. Santos had traveled to Albuquerque from Massachusetts with her 3 young children. The 3-year-old who had just been brought to the hospital, a 6-year-old, and an infant. She had been accompanied by 2 other adults, a woman named Christina Hopkins Paynecanter, 46, and Paynecanter's son, Austin Bing, 28. The group had been staying in a studio apartment on Gold Avenue SE in Albuquerque, owned by a man named James Welch, 48. As investigators spoke with the older child, the 6-year-old, a deeply troubling account began to emerge. The 6-year-old described what had been happening to her younger sister. She described how one of the adults in the apartment had bound the 3-year-old's wrists and ankles with shoelaces and secured her to the frame of a bed. She described the apartment as a place where the children had been subjected to harm in multiple forms. She described the routine nature of the restraint. Investigators then examined the 3-year-old's body more thoroughly. What they found was consistent with the account the 6-year-old had provided, and then some. The child's injuries were not the result of a single fall. They were in different stages of healing, indicating that harm had been done to her on multiple occasions over an extended period of time. The pressure marks on her ankles and wrists were consistent with having been restrained. The overall picture was one of chronic, sustained harm that had been occurring not for hours but for an extended period. The investigation also produced evidence that all 3 children had been subjected to forms of harm beyond physical restraint. All 3 children were believed by investigators to be victims of contact that was criminal in nature and involved additional individuals connected to the household. Arrest warrants were secured for all 4 adults, Carrie and Santos, Christina Hopkins Paynecanter, Austin Bing, and James Welch. All 4 were charged with child abuse resulting in death and child abuse. Santos was additionally charged with tampering with evidence. All 4 were booked into the Bernalillo County Jail. Santos told investigators she had left Massachusetts to escape an abusive situation. She said she had been trying to protect her children. But the record that investigators assembled did not support the account of a mother who was protecting her children. Santos had, according to the criminal complaint, been present while her children were restrained. She had agreed, after initially objecting, to go along with the false account about a gas station fall. She had acknowledged in her own statements that the injuries to her 3-year-old daughter had occurred inside the apartment on Gold Avenue. Her 3-year-old daughter did not survive. In May of 2025, the case took a significant turn in the criminal proceedings. Carrie Santos appeared before a district judge for a competency hearing. Psychiatric evaluations had been conducted. The results of those evaluations led to a finding by the court. Santos was not mentally competent to stand trial. The judge made that ruling on the record. The matter was then referred to a dangerousness hearing, a separate legal process under New Mexico law that determines what happens to an individual who has been found incompetent and potentially poses a continuing risk. The finding of incompetence is a legal status, not a moral absolution. It does not alter the facts of the investigation as established. It does not change what was found in that apartment, what was found on that child's body, or what the 6-year-old described when investigators spoke with her. It changes only the path through which the courts of Bernalillo County are able to address those facts. The surviving children were placed in the custody of CYFD following the arrests. They faced an enormous road of recovery ahead of them, not just physical, but deeply personal and developmental. Children who have experienced what these children experienced require sustained, specialized support over years, not weeks or months. What happens next for them is the work of the child welfare and mental health systems, and it is work that begins in the courtroom but does not end there. The 3-year-old girl whose life was taken in an Albuquerque studio apartment in the early morning hours of January 12, 2024, has not been publicly named in this documentary. She was 3 years old. She was someone's daughter. She deserved every single day she did not get to have. The courts of Bernalillo County are continuing to navigate the legal complexities that the competency finding created. The other defendants in the case have their own proceedings moving through the system. The full accounting of what happened in that studio apartment on Gold Avenue has not yet been delivered in its final legal form. But the investigation is complete. The facts are established. And the record is clear. A 3-year-old girl did not survive her stay in Albuquerque. The adults who were responsible for her safety face serious felony charges in the 2nd Judicial District Court of Bernalillo County. And the court system of New Mexico is working, however imperfectly, however slowly, to answer for what was done to her. She deserved more. Every child deserves more. If this case reminded you why it matters that stories like this are told, that the victims are not forgotten, that the facts are documented, that accountability is pursued, please like this video and subscribe to Cold Case Hour. 2 more cases remain. Thank you for staying with us through every single one of these stories. Case 9, Diana Garcia. October 1st, 2021. 2nd Judicial District Court, Bernalillo County, New Mexico. The law of New Mexico, like the law of most states, recognizes that the failure to act can be as legally significant as an act itself. That a person who witnesses ongoing harm being done to a vulnerable child, who lives alongside that harm, who cannot claim ignorance of its existence, who has the ability and the authority to intervene or to report, and who does none of those things, bears a moral and legal responsibility for the outcome of that harm. This is not a controversial principle. It is the foundation upon which a series of New Mexico statutes are built, including the laws governing mandatory reporting of suspected child abuse and the laws governing child abandonment. The case of Diana Garcia, a grandmother, not a mother, though the dynamics of care and responsibility that define this case require her inclusion in any examination of the adults who failed the children of Albuquerque, is, at its core, a case about what happens when silence becomes complicity. On October 1st, 2021, Albuquerque Police Department officers responded to a 911 call from a home near San Pedro Drive and San Antonio Drive in Albuquerque. What they found inside that home stopped them. A 2-year-old girl, Diana McGrory, named after her grandmother, was lying on the floor of her father's home, unresponsive and unclothed but for a diaper. She had visible bruising across nearly every part of her body. Her face, her ears, her forehead, her arms, her legs, her torso, her feet, each bore evidence of harm. She had burns on her thigh, on her backside, and on each of her palms. A medical examination would later reveal that she had an adult bite mark on one leg, and that portions of her scalp were missing. A scan of her brain revealed bleeding. A pathologist established that the cause of her death was blunt trauma, and the manner of death was formally declared a homicide. Diana McGrory was 2 years old. Her father, Michael David Garcia, was arrested the same day. Diana Garcia, Michael's mother, Diana McGrory's paternal grandmother, was not arrested immediately. Investigators continued to work the case, examining the full picture of who had been living in that household and what each person in it knew. What they established was significant. Diana Garcia, the grandmother, had been living in that home alongside her son Michael, his 4 children including little Diana, and the daily reality of what was happening inside those walls. The bruises were visible. The burns were visible. The condition of those children was not something that could be overlooked in the close quarters of a shared household. The investigation determined that Diana Garcia had been aware, or should have been aware, of the ongoing harm being done to the children in that home, and that she had not reported it, had not called for help, had not intervened. In October of 2021, following the arrest of her son, APD detectives arrested Diana Garcia on a charge of child abuse resulting in great bodily harm or death. Michael Garcia's criminal proceedings moved forward separately. He pleaded guilty to second-degree murder and 3 counts of child abuse in September of 2023. Judge Clara Moran accepted the plea. He was sentenced to 28 years in prison on September 29, 2023. Additionally, the state of New Mexico and its Children, Youth, and Families Department faced a civil lawsuit filed on behalf of Diana McGrory's surviving siblings. A lawsuit that alleged CYFD had negligently placed those children with Michael Garcia despite knowing about his history of criminal behavior and domestic violence, and despite a prior police warning. That lawsuit was settled in December of 2025 for $1.7 million, which was designated for the surviving children. Diana Garcia's case, the grandmother's case, moved through the courts on its own timeline. She pleaded no contest to child abandonment resulting in death and failure to report child abuse. The no contest plea carried the same legal weight as a guilty plea for purposes of sentencing. Judge Jennifer Wernersbach heard the case at sentencing and was direct about what she found. Diana Garcia had ignored the obvious, ongoing harm being done to her grandchildren. She had chosen silence. She had chosen to remain in that household without taking a single step toward protection for those children. Judge Wernersbach sentenced Diana Garcia to 3 years in prison, followed by 5 years of probation. The 3-year sentence generated discussion. Some in the community felt it did not adequately reflect the gravity of what had been allowed to unfold. Others noted that the law in this case was specifically addressing the failure to report, that Garcia had not physically harmed Diana McGrory herself, and that the direct perpetrator had received 28 years. The sentencing disparity reflects the legal distinction between active and passive culpability. But what this case ultimately illuminates is a dimension of child protection that is sometimes overlooked in the focus on the perpetrator of direct harm. The people who are present, who see what is happening, and who say nothing. In every case where a child suffers prolonged harm before anyone intervenes, there is almost always a question about who else was there. Who else knew? Who else could have spoken up and did not? New Mexico has mandatory reporting laws that require certain categories of people, and in some contexts, all people, to report suspected child abuse to authorities. The failure to make that report is itself a crime. Diana Garcia's conviction and sentence stand as the judicial record of what happens in Bernalillo County when that obligation is not met. Little Diana McGrory deserved to have someone in that house speak for her. She was 2 years old. She was entirely dependent. She was surrounded by adults, and not a single one of them protected her. Michael Garcia is serving 28 years. Diana Garcia served her sentence. The CYFD lawsuit has been settled, and somewhere, Diana McGrory's siblings are growing up, navigating what they witnessed, carrying what was done to them, hopefully in the care of people who will give them what they were denied for far too long. Little Diana deserved so much better. The record of the 2nd Judicial District Court of Bernalillo County says so, and this documentary says so. If this case reminds you of the importance of speaking up, of reporting concerns, of never looking the other way when a child may be in danger, please like this video and subscribe to Cold Case Hour. One final case remains tonight. We will not leave without telling it. Case 10, Samantha Sanchez. May 5, 2022. 2nd Judicial District Court, Bernalillo County, New Mexico. Every case in this documentary has told a story with a specific shape, a specific configuration of choices, circumstances, and failures that led to a child being placed in harm's way. Some involve the introduction of dangerous substances into a child's environment. Some involve physical harm. Some involve the failure of supervision. Some involved all of the above. What they share is the thread of adult decision-making that placed children, who could not make decisions for themselves, who could not protect themselves, in positions of danger. The final case in tonight's documentary is, in some respects, a condensed version of all of these themes. It is a case that encompasses firearms, domestic instability, substance exposure, chronic neglect, and a pattern of behavior so well documented by the systems designed to protect children that by the time the most acute incident occurred, Albuquerque authorities had already been to Samantha Sanchez's door more than 6 times. On May 5, 2022, Albuquerque Police Department officers were dispatched to a complex on Central Avenue in E. At the time of the call identified as the Four Hills Studios location, in response to a reported shooting. When officers arrived and searched the area, they located an adult male and a toddler. The toddler, Sanchez's son, had sustained a gunshot wound. 3 of his left toes had been severely injured by the discharge. He was transported to the University of New Mexico Hospital, where he was treated for injuries that were characterized as serious but not life-threatening. Investigators located Samantha Sanchez and her boyfriend, Lucian Apachito, in connection with the incident. Both provided accounts to police, and while the 2 accounts differed in certain details, the overall picture they painted was consistent on the central facts. The couple had been in a domestic dispute. Sanchez had retrieved a firearm during the course of that confrontation. The 2 struggled over the weapon. During that struggle, it discharged. The bullet, or its deflection from another surface, struck the toddler in the foot. A toddler was present during an adult domestic dispute. A firearm was introduced into that dispute. The weapon discharged. A child was injured. There is no benign version of this sequence of events. There is no reading of these facts in which a small child's presence in that environment, at that moment, is anything other than the result of adult choices that failed to prioritize that child's safety. But the investigators who worked this case were also aware that May 5, 2022, was not the beginning of the story of Samantha Sanchez's relationship with child welfare authorities. Court records established that Sanchez had accumulated at least 6 CYFD cases by the time of the shooting incident. 6. A separate criminal complaint from January of that same year, just months before the shooting, documented that Sanchez had taken a 1-year-old child to UNM hospital and that a doctor had found the child's symptoms consistent with exposure to methamphetamine. And there were additional documented incidents in which Sanchez's young children had been left to fend for themselves without appropriate supervision for extended periods. 6 CYFD cases. Exposure to controlled substances. Unsupervised children. And then, on May 5, 2022, a loaded firearm introduced into a domestic dispute with a toddler present. Following her arrest, prosecutors sought to have Sanchez held in pretrial detention, arguing that she had demonstrated a pattern of disregard for the safety of her children and others. A judge ultimately allowed her release under strict conditions, including no unsupervised contact with her children. Samantha Sanchez ultimately pleaded guilty to 3 counts of child abuse, charges related to the shooting incident and the earlier methamphetamine exposure case. She appeared before a judge for sentencing in the matter. Judge Bruce Fox sentenced Sanchez to 1 year in custody and 5 years of probation. The sentence was, in the eyes of some community members, insufficient given the breadth of the documented pattern. But the legal system must work within its established framework, and the charges to which Sanchez pleaded guilty carried the sentencing range that they carried. 1 year in custody, followed by 5 years of supervised probation. What the case of Samantha Sanchez places in sharpest focus is the cumulative nature of risk to children in unstable household environments. It is rarely one single catastrophic decision that places a child in danger. It is a pattern. It is a series of choices, a series of incidents, a series of moments in which the signals were present and the intervention, for whatever combination of systemic and individual reasons, was either insufficient or delayed. 6 CYFD cases. Multiple documented incidents. A child who survived a shooting. A toddler who tested positive for a controlled substance. And through all of it, children who had no say in any of it. The children in Samantha Sanchez's care were eventually placed under protective conditions. The legal system engaged repeatedly, if imperfectly, with the pattern of behavior documented in this case. The final criminal resolution, a guilty plea and a combination of custody time and supervised probation, closed the criminal chapter of this particular case in the courts of Bernalillo County. But the children at the center of it will carry the weight of those years with them long after every courtroom in this case has been locked up for the night. Every child in Albuquerque, in every household, on every street, across every neighborhood, deserves to be safe. They deserve adults who choose safety over conflict, who choose stability over chaos, who choose their children's well-being over every other competing consideration. When that does not happen, the consequences fall entirely on the children who had no say in the matter. Samantha Sanchez's son survived. That matters. That, in this landscape of cases, is worth acknowledging. But surviving a shooting in your mother's apartment at the age of approximately 1.5 is not the childhood that any child is owed. The courts of Bernalillo County addressed this case. The record exists. The guilty plea stands. And the community of Albuquerque is left, as it always is after cases like this, asking the necessary and never fully answerable question: what more can be done? That question, what more can be done, is the thread that connects every single one of the 10 cases documented in tonight's episode of Cold Case Hour. From Michelle Martins in Northwest Albuquerque in 2016 to Tabitha Molina and the devastating events of May 2026, these cases span a decade. They span different neighborhoods, different circumstances, different degrees of culpability, different legal outcomes. But they share the same fundamental fact. Children were harmed because the adults responsible for their safety chose, in various ways and for various reasons, not to provide it. The New Mexico Children, Youth, and Families Department. The 2nd Judicial District Court of Bernalillo County. The Albuquerque Police Department's Crimes Against Children Unit. The Office of the Medical Investigator. The prosecutors and public defenders and judges who move these cases through the legal system. Every single one of these institutions plays a role in the chain of accountability that these children deserve. None of these institutions is perfect. Each has faced legitimate criticism across the cases covered tonight. But each is also essential. Each is part of a system that, however imperfectly, is designed to ensure that what happened to these children is documented, prosecuted, and placed permanently into the public record. Documentation matters. Prosecution matters. The public record matters. Because the children who cannot speak for themselves deserve to have their stories told. Not sensationalized, not exploited, but told accurately, respectfully, and with the full weight of the investigative and judicial record behind them. That is what Cold Case Hour is committed to providing. Tonight's cases were drawn entirely from verified court records, official criminal complaints, and credible reporting from outlets including the Albuquerque Journal, KRQ News 13, KOB4, the Santa Fe New Mexican, and the Albuquerque Police Department's own public releases. Every name, every date, every charge, every sentence presented in this documentary is grounded in the documented public record. This channel does not speculate. This channel does not embellish. This channel tells the story as the courts and the investigators established it. If you are a parent, a neighbor, a teacher, a friend, or anyone who spends time around children, the single most powerful thing this documentary can offer you is a reminder that children cannot advocate for themselves. They cannot call the police. They cannot file a report. They cannot remove themselves from dangerous environments. The only protection available to them is the protection that adults choose to provide. And when that protection fails, it is the community, through its child welfare systems, through its mandatory reporting obligations, through its willingness to say something when something needs to be said, that stands between a vulnerable child and the worst possible outcome. If you ever have a concern about the safety of a child, even a concern you are not sure about, even a concern that feels uncertain or uncomfortable, please reach out to the Child Help National Child Abuse Hotline, 1-800-4-A-CHILD. That is 1-800-422-4453. It is free, it is confidential, and it is available around the clock every single day of the year. Trained counselors are there to help you understand your options and take the right next step. Every single child featured in tonight's documentary deserved to be safe. Some of them survived and are healing. Some of them did not. All of them deserve more. And they deserve to be remembered. Thank you for watching Cold Case Hour. If this documentary affected you, if it educated you, moved you, reminded you of something important, please like this video right now. Every like helps this content reach more people. And if you have not subscribed yet, please subscribe to Cold Case Hour so you never miss an episode. This work depends entirely on this community. Your support, your clicks, your comments, your subscriptions, is what makes it possible to keep telling these stories. Leave a comment below. Tell us which case affected you the most. Tell us what you think about the way the justice system handled these cases. Tell us what you believe could be done differently. This is a community, and your voice matters here. New episodes drop regularly. We have more stories to tell, more cases to document, more children whose names deserve to be spoken. We will see you in the next one. This is Cold Case Hour. Thank you for being here.